You've owned firearms your entire adult life. You bought your first rifle at 19. You carried legally for decades. You kept a handgun in the nightstand not because you were afraid, but because you were prepared, because that's who you are: responsible, careful, a protector. And now at 63 or 68 or 72, after all those years of doing everything right, a single document filed without your knowledge, a single court proceeding you were never told about, or a single new state law you haven't heard of yet could strip every one of those rights away. Permanently. No trial, no conviction, no criminal record required. And here's the part that will stop you cold. It could happen because of a prescription your doctor wrote, a moment of grief after losing your spouse, or a routine legal filing made by someone in your own family trying to help you. This is not a hypothetical. This is happening right now in states across this country to gun owners just like you. And most of them never saw it coming. Let's talk about what's actually going on, because the threat isn't just one law, it's a system, a patchwork of state-level policies, federal intersections, and legal mechanisms that are quietly reshaping what it means to be an armed American over 60. And the older you get, the more exposure you have. That's the trap, not some dramatic criminal act, not a felony. The trap is age itself, the prescriptions that come with age, the estate planning that comes with age, the health scares, the memory concerns, the moments of vulnerability that every human being faces as they get older. Those are the exact pressure points this system targets. And if you don't understand it, you can't protect yourself from it. So why is this happening now? Why are gun owners over 60 suddenly more at risk than at any other point in their lives? 3 reasons, and each one is more serious than the last. First, red flag laws, formerly called Extreme Risk Protection Orders, or ERPOs, have now been passed in over 20 states, with more pending. These laws allow a family member, a household member, a law enforcement officer, and in some states, a medical professional or school official to petition a court to remove your firearms without you being present at the hearing. The standard is not beyond a reasonable doubt. It is not even probable cause. In many states, it is simply a judge deciding there is reason to believe you might pose a risk. That's it. That's the bar. And once that order is issued, even temporarily, you are prohibited under federal law from possessing firearms. Federal law, not just state. Every gun you own becomes illegal to possess from the moment that order is served. Now think about who has the most contact with medical systems, the most interactions with adult children managing their affairs, the most visible moments of emotional distress: a spouse dying, a diagnosis, a fall, a hospitalization. Older Americans, people just like you. That's the first layer. Now here's where it gets deeper. The second layer involves mental health records and the federal prohibited persons list, what the ATF calls the NICS database. You may not realize this, but certain mental health adjudications, formal legal findings, not just a diagnosis, can trigger a lifetime federal firearms prohibition under 18 USC 922G. This has been true for decades. What has changed is how aggressively states are now reporting those adjudications to the federal database, and how broadly some states are interpreting what qualifies. In some states, being involuntarily committed, even briefly, even decades ago, can now disqualify you. In others, a guardianship proceeding, if it includes certain language about mental capacity, can trigger a report to NICS. Here's the scenario no one is telling you about. Your family loves you. You had a health scare. Your adult children, out of genuine concern, initiate a guardianship or conservatorship proceeding to help manage your finances during recovery. It's meant to be temporary. The attorney uses standard language. The judge signs a standard order. And somewhere in that paperwork, in a phrase you never focused on, is a finding that qualifies as a mental health adjudication under federal law. Your name goes into the federal database. You go to your gun safe the next morning and legally, you are no longer allowed to open it. No one called you, no one warned you. Your family didn't know, your attorney didn't flag it, and now you are a federal prohibited person. The third layer is the one that may be the most quietly dangerous of all. It involves the intersection of prescription medications and state firearms laws. Now, let me be precise here, because this varies dramatically by state. Federal law does not automatically prohibit gun ownership based on prescription drug use alone, but state laws are a different matter, and they are changing. Several states have proposed or passed legislation that creates new categories of prohibited persons connected to certain medications, particularly those prescribed for conditions like PTSD, anxiety, or depression. Some states require doctors to report patients to state law enforcement databases if they believe a patient poses a risk, and that report can trigger a state-level firearms prohibition. Here's what that means for you practically. You're a veteran. You've dealt with PTSD for 30 years. You've managed it responsibly. You've been medicated, monitored, and functional. You've never been violent. You've never been adjudicated. You've never been committed. But in your state, a new reporting law just went into effect. Your doctor files a report, and suddenly your state-issued carry permit is suspended pending review. Or you're not a veteran. You lost your spouse of 40 years and went through a dark 6 months. Your doctor prescribed an antidepressant. You got better. You moved forward. But in your state, that prescription, if reported under a new statute, created a record that now sits in a database waiting to be activated the next time you try to purchase a firearm, renew a permit, or if a family member ever files a concern report under a red flag statute. The door that looked closed behind you is still open. Let me show you what this looks like in real numbers. 2 men, same age, same background, both 67, both lifelong gun owners. Robert lives in a state without red flag laws and with strong due process protections for firearms rights. His daughter becomes concerned after he mentions feeling overwhelmed following his wife's passing. She calls his doctor. The doctor notes the conversation. Robert continues owning his firearms. He never loses a single right. Over time, he recovers. His firearms stay in his home. His family sleeps better knowing he's protected. Gerald lives 2 states away. Same situation, same grief. His daughter, equally well-meaning, files a red flag petition. She doesn't fully understand what she's initiating. She just wants him to talk to someone. A judge issues a temporary order at an ex parte hearing Gerald was not invited to attend. Law enforcement comes to Gerald's home and removes 11 firearms. His carry permit is suspended. The temporary order is later vacated, but the federal reporting has already occurred. Gerald hires an attorney. It takes 14 months and over $9,000 in legal fees to restore his rights. 2 of his firearms are damaged in storage. And for 14 months, the man who spent 40 years protecting his family cannot protect himself. Same grief, same family love. 2 entirely different outcomes. One difference, the state they lived in, and whether Gerald knew what his rights were before the petition was filed. So what do you actually do? How do you protect yourself? Start here and be serious about each step. First, know your state's current red flag law status and the exact petition rules. Who can file? What the standard is? What the process looks like? This is not optional knowledge anymore. It is foundational. Second, review any guardianship, conservatorship, or power of attorney documents in your estate plan. If you have a living trust, a healthcare directive, or any legal document that touches on mental capacity, have an attorney review the specific language for any phrasing that could trigger a federal mental health adjudication. This is a niche question. Most general attorneys won't catch it unless you ask specifically. Third, if you are a veteran receiving VA care, understand your rights under the VA reporting process. There is a specific appeals mechanism. Know it exists. Know how to use it. Fourth, if you are managing a health condition and are prescribed medications that touch on mental health, not to stop treatment, that's between you and your doctor, but to have a direct, honest conversation about what, if anything, is being reported to state databases under your state's current law. You have a right to that information. Fifth, consider a firearms trust. A properly structured firearms trust can protect your collection from certain legal vulnerabilities, ensure lawful transfer to heirs, and in some cases provide a layer of legal protection that individual ownership does not. Sixth, Document your current legal status now. If you are legally cleared to own firearms today, having that documentation current and organized matters. If something is ever challenged, the paper trail you built before any incident carries enormous weight. And finally, talk to your family, not to scare them, not to be adversarial, but to have an honest conversation about what a red flag petition actually does, what it cannot undo quickly, and what the right path is if they are ever genuinely concerned about you. Because in most cases, families file these petitions with love and without understanding the legal machinery they are activating. Knowledge inside your family is the first line of defense. Here is what you need to hear before this ends. The rights you have carried your entire life are not safe by default. They are not protected simply because you've done nothing wrong. They are not guaranteed because you've been a responsible owner for 50 years. They are protected only by your awareness, your documentation, your legal preparation, and your understanding of a system that has grown significantly more complicated in the last 5 years. You are not being targeted because you are dangerous. You are exposed because you are older, because you are more likely to encounter medical systems, legal proceedings, and family interventions, and because not enough people are talking about how those intersect with your gun rights. This video is that conversation. If you found this useful, save it. Send it to someone over 60 who owns firearms and thinks this couldn't happen to them. And if you want to stay ahead of the laws that are still moving, subscribe, because we watch these changes so you don't get blindsided. Your rights took a lifetime to build. Don't let one overlooked law take them in an afternoon.